Some federal judges across the country are getting increasingly upset with the Trump administration for not complying with their orders in cases involving immigrants. The New York Times reports, quote, at least 35 times since August, federal judges have ordered the administration to explain why it should not be punished for violating their orders in immigration cases. For instance, one judge ordered an immigrant be released from custody in Minnesota, but instead the man was let go in El Paso. The Times says this has come up multiple times in California, Texas, Florida, Massachusetts, Michigan, New York, West Virginia, and Puerto Rico. Former federal judge Jeremy Fogel joins us now. He is currently the executive director of the Berkeley Judicial Institute at Cal Berkeley's Law School. Judge, thank you so much for being here. What recourse, if any, do judges have? Does holding someone in contempt really have teeth?
Hello, everyone. Carla's ready. Stop what you are doing right now and pay attention to this, because what I am about to tell you is not spin. It is not opinion. It is not some anonymous source whispering to a reporter off the record. This is a sitting judge in a court of law in the state of New York looking at Donald Trump's sworn testimony and writing in an official court order that his words under oath were.
Well, first of all, thank you for inviting me to be with you. The contempt power is a very rarely exercised power. You know, the public sometimes thinks contempt is something judges do all the time, and they pound their gavel and they throw people in jail. But actually, it's a very limited power. It's used very sparingly. And for a judge to get to the point where they think about doing it, they have to be pushed pretty far.
And I am using the judge's exact language here. Hollow and untrue, not misleading, not vague, not open to interpretation. Hollow and untrue. That is a judge telling the world that the President of the United States lied under oath, and it gets worse from there, because this is not just about one moment. This is not just about one bad day on the witness stand.
The recent orders that have been made, and you mentioned that in your opening, in Minnesota, Judge Schultz, who, by the way, is a very conservative judge, known as such. This is a bipartisan issue, and he was the one who ordered somebody released, and it turned out the person wasn't there. Judge Stearns in Massachusetts, who's on the other side of the aisle, had a similar.
What we are looking at right now is a documented pattern exposed by courts and fact-checkers and legal filings showing that Donald Trump has repeatedly said one thing under oath in one proceeding and then said the complete opposite under oath in another proceeding. We are talking about sworn affidavit that directly contradicts sworn depositions. We are talking about a judge who wrote in his final ruling that Trump's credibility was severely compromised, that his fraud shocked the conscience, and that his lack of remorse borders on pathological. These are not words from a political opponent. These are words from a judge who sat through months of testimony and evidence. And here is why this matters more than anything else happening in politics right now. Because once a judge puts it in writing that your testimony is not credible, that your sworn words ring hollow and untrue, that changes everything. It changes how other courts treat you. It changes how prosecutors approach you. It changes how juries weigh your word against documents and witnesses. And most importantly, it creates a legal paper trail that follows you into every future case, every future hearing, every future dispute where your credibility is on the line. Trump is the sitting president of the United States, and multiple judges have now gone on record saying they simply do not believe him when he speaks under oath. That is extraordinary. That is unprecedented. And that is exactly what we are breaking down today. Let me walk you through the evidence piece by piece, because when you see it all laid out together, the picture is devastating. We have got the judge's own words from the civil fraud trial. We have got the contradicting sworn statements about Trump's role in his own company. We have got the appeals court confirming the credibility findings. We have got his former CFO caught lying on the stand in the same case. And we have got the broader pattern that legal experts say makes Trump's testimony presumptively unreliable in any courtroom going forward. Every piece of this is documented. Every piece of this is in the public record. And every piece of this is going to follow Trump into every legal battle he faces for the rest of his presidency and beyond. This is a big one. Let us get into it. To understand what is happening here, you need to go back to the New York civil fraud trial. That is where the most damaging judicial findings about Trump's honesty came from. The New York Attorney General brought a massive civil fraud lawsuit against Trump, his adult sons, the Trump Organization, and several executives. The allegation was simple but enormous. For over a decade, Trump and his company had inflated the value of their properties by hundreds of millions of dollars. sometimes billions, to get better deals from banks and insurance companies. They were accused of making their financial statements look far more impressive than reality, and then using those false numbers to secure favorable loans and lower insurance premiums. The case went to trial and lasted for months. Trump himself took the witness stand. Now, here's where it gets really interesting, because Trump did not behave like a normal witness. According to court records and reports from journalists who were in the room, Trump was combative. He was evasive. He gave long, rambling speeches that had nothing to do with the questions being asked. He attacked the attorney general. He attacked the judge. He attacked the process. And when he was asked direct questions about the financial statements and property valuations, he deflected. He blamed his employees. He blamed his accountants. He said the numbers were actually conservative, that his properties were worth far more than what the statements showed. The judge who presided over the case was not impressed. In fact, he was the opposite of impressed. During the trial, Trump made a statement in the hallway outside the courtroom that appeared to violate a limited gag order. The gag order prohibited public comments about the judge's staff, specifically his law clerk, who had been receiving death threats after Trump targeted her on social media. Trump told reporters that the judge had a very partisan person sitting alongside him. The judge believed Trump was referring to the law clerk. Trump's lawyers claimed he was talking about a different person. So, the judge called Trump to the stand to explain himself under oath. Trump testified that he was referring to someone else. And the judge, after listening to Trump's explanation, wrote in his official court order that he found the testimony hollow and untrue. Let that sink in for a second. A judge in a formal written order said the president's sworn testimony rings hollow and untrue. He said Trump was not credible, and this was not some minor procedural issue. This was Trump testifying under oath about what he meant by his own words, and the judge deciding he was lying about it. Trump was fined $10,000 for violating the gag order, and that finding that his testimony was not credible became part of the permanent record of the case. But it did not stop there. When the judge issued his final ruling, he went even further. He wrote that Trump's overall testimony at trial was not credible. He said Trump rarely responded to the actual questions being asked, that he frequently interjected long, irrelevant speeches on issues far beyond the scope of the trial. He said Trump's refusal to answer questions directly, or in some cases at all, severely compromised his credibility. And in describing the fraud itself, the judge used language that is almost unheard of in a civil case. He said the fraud shocked the conscience. He said Trump and his co-defendants showed a complete lack of contrition and remorse that borders on pathological. Borders on pathological. Those are the judge's exact words. Trump was hit with a penalty of hundreds of millions of dollars. He was barred from running businesses in New York for years. His sons were barred, and the Trump Organization was ordered to submit to an independent monitor. Now, an appeals court later reduced the financial penalty. But here's the critical part that everyone needs to understand. The appellate panel upheld the finding that Trump's testimony was not credible. A majority of the 5-judge panel agreed with the trial judge's credibility determination. So it is not just one judge anymore. It is multiple judges at multiple levels of the court system saying on the record that they do not believe Donald Trump when he speaks under oath. The business ban stayed in place. Trump is still barred from running a company in New York. His sons are still barred, and the finding that his testimony was not credible is now confirmed on appeal, meaning it carries even more weight in any future legal proceeding. Now, let us talk about the contradicting sworn statements, because this is where the pattern becomes really clear. When Trump became president, he signed a sworn affidavit stating that he had resigned from all of his positions at the Trump Organization. This was supposed to show that he was separating himself from his business interest while serving as president. A formal sworn statement filed with the court saying he had stepped away from the company. But then years later, in a separate deposition connected to a different legal matter, Trump was asked whether there was ever a period of time when he did not serve as president of the Trump Organization. And his answer contradicted what he had previously sworn to. He said he was an inactive president during his time in the White House, but that he never actually stopped holding the title. Think about what that means. In one sworn document, he says he resigned from all positions. In another sworn proceeding, he says he never stopped being president of the company. Both statements were made under oath. Both carried the legal weight of sworn testimony, and they directly contradict each other. The New York Attorney General's office flagged this contradiction in court filings, pointing out that Trump's own words under oath told two completely different stories depending on which proceeding he was in. And here's the irony that makes this even more unbelievable. When Trump sat for his deposition with the Attorney General's office, he invoked his Fifth Amendment right against self-incrimination and refused to answer questions over 400 times. He would not answer a single substantive question. And back when he was running for president, Trump himself said at a campaign rally that the mob takes the Fifth and asked, "If you are innocent, why are you taking the Fifth Amendment?" Those were his own words, his own standard. And then he did the exact same thing he criticized others for doing. This is the core of the problem. When you have a pattern of saying whatever is convenient in the moment, regardless of what you said before, regardless of what the documents actually show, judges stop giving you the benefit of the doubt. And that is exactly what has happened. Courts and juries have increasingly relied on documents, emails, financial records, and third-party witnesses rather than Trump's word when trying to determine what actually happened. His own former chief financial officer was found to have lied under oath during the fraud trial. That same executive had previously pleaded guilty in a separate criminal tax fraud case where the Trump organization itself was convicted on multiple felony counts. Think about what that says about the organization Trump built and ran for decades. The top financial executive lied on the stand. The boss found not credible on the stand. The company convicted of felonies. This was the culture at the top of the Trump organization. A culture where sworn testimony was treated as just another tool for telling the story you wanted people to hear rather than the truth you were legally obligated to tell. And that culture, according to the judge, was set from the very top. Let us break down why this actually matters. Takeaway number 1, judicial credibility findings follow you into every future case. When a judge writes in an official court order that your testimony is hollow and untrue, that does not just disappear after the case ends. It becomes part of the legal record. Other judges, other prosecutors, other opposing attorneys can cite that finding in future proceedings. They can point to it and say a court has already determined that this person's sworn testimony is not reliable. That is devastating for anyone facing legal scrutiny. And Trump is facing legal scrutiny on multiple fronts right now. The investigations, the ongoing financial reviews, potential perjury exposure from contradicting sworn statements. In every single one of those proceedings, the opposing side can now reference the written finding that Trump's testimony was not credible. And it is not just one judge anymore. The appellate panel reviewed the case and agreed with the credibility determination. That means this finding has been reviewed and upheld by a higher court. It is a confirmed judicial finding at multiple levels of the court system. For any lawyer preparing a case against Trump, that is gold. You do not have to prove from scratch that Trump is an unreliable witness. The courts have already done that work for you. All you have to do is point to the existing record and say, this man has been found not credible under oath by multiple judges. Proceed accordingly. Takeaway number 2, the contradicting sworn statements create real perjury exposure. When you have a sworn affidavit saying he resigned from all positions and a sworn deposition saying he never stopped being president of the company, that is exactly the kind of contradiction that gets prosecutors interested. One of those statements has to be false. They cannot both be true. Layer that on top of the judge's finding that his trial testimony was hollow and untrue and the overall determination that his credibility was severely compromised, and you start to see a pattern that prosecutors can use. A pattern of someone who treats sworn testimony as flexible. Someone who shapes his story to fit the moment rather than telling the truth. The judge described this as a lack of contrition that borders on pathological. That word pathological means the judge is not describing a one-time mistake. He is describing a pattern of behavior, a fundamental approach to truth-telling that the court found deeply troubling. In any legal proceeding, that pattern is incredibly damaging. It means judges and juries are going to look at the documents first, and Trump's words second. They are going to trust the emails over his explanations, the financial records over his claims, the third-party witnesses over his version of events. Takeaway number 3. This pattern is exactly what opponents needed to build a credibility narrative heading into the midterms. We are heading into a major election with a sitting president whose own judges have written in formal court orders that his testimony is not believable. Opponents are going to point to the judge's words, hollow and untrue, severely compromised credibility, lack of contrition bordering on pathological, and they're going to use those phrases in campaign ads and town halls and debates across the country. And the problem for Trump is that he cannot just dismiss this as a political attack. This is not a quote from a Democratic politician. This is a judge's written ruling. This is an appeals court's confirmation. This is the official legal record of the United States court system saying that Donald Trump is not credible when he speaks under oath. That is different from anything we have seen before. Past presidents have been accused of lying. Past presidents have been caught in contradictions. But no sitting president has ever had multiple judges formally writing court orders that his sworn testimony is not to be believed. The question is not whether Trump lied under oath. The judges have already answered that question. The question now is what happens next. Will prosecutors pursue perjury charges based on the contradicting affidavit? Will other courts cite the credibility findings in new cases? Will voters care when they head to the polls? Trump has survived a lot of things in his career. He survived impeachments and indictments and investigations and scandals that would have ended any other politician's career many times over. But surviving a credibility collapse in the court system is a different kind of challenge. You can spin the media. You can attack your opponents. You can fire up your base at rallies. But you cannot spin a judge's written ruling. You cannot attack your way out of an appellate confirmation. And you cannot rally your base into a courtroom where sworn testimony is weighed against hard evidence. The courts have spoken, and what they said should concern everyone.